Welcome to Subramani. Please press the bell icon. Please subscribe, because I'm not seeing the same growth rate of subscribers which I had in 2024 or 2023, right? I'm going to now talk about estate planning in India, not particularly for women, but generally estate planning in India, or rather the kind of mistakes that I see people make. So the first mistake, which is unbelievable, I see many people, maybe 65, 66, 70, not creating a will, right, which is absolutely stupid. I know one parent who said, oh, I'm giving you so much, go and you go and fight and get it. There's no problem. I will not make a will. Now this is amazingly stupid. You earned all your money, or you slogged all your life to earn money to give it to leave it for your children, because you didn't spend it. So if you didn't spend it, it's obviously you intentionally or otherwise you're leaving it for your children. Please take care of it. What is the point in not making a will? Not making a will because you didn't know it, or not making a will is different. But not making a will because of you are too lazy or something is different. But not making a will deliberately is super maha stupid. So please don't do that. Whichever part of the world you are in, it is necessary to make a will. I don't know about other countries, so I'm not talking about what happens in US, what happens in Pakistan or anything like that. I'm talking only about India. But if you are an NRI, whichever part of the world you are, if you have Indian assets, you need to make a will. Otherwise the property will go as per the Hindu Succession Act or the Indian Succession Act or the Sharia law. That may not be your intent. Don't think it is obviously going to your wife and children and all that. No, it's not. So first of all, creating a will is important. Secondly, many people, very rich, try to save professional fees by saying, can you send me a draft of the will? I will just print it and keep it at my house. Don't do that. Each will is going to be different, and it does not cost much. In terms of rupees, it is about what, 10,000 rupees or 12,000 rupees, 15,000 rupees max. If you are living in a metro and you have a house which is worth 3 crores, this is what percentage of that are we talking about? 1% is 3 lakhs, right? So we are talking of 10,000, 15,000. That is hardly worth saving, but yes, many people do. Rich, very rich people have all done that. People have called me and said, can you give me a draft of a will? It's available on Google Boss, but I would say don't do that. Next is not changing nomination when there is a change in your family. Whenever we take up a job, maybe 21, 22, 23, we are obviously not married, and so your mother would be the nominee. So very good chance that your mother is a nominee in the Demat account that you open. Your mother is a nominee in the Provident Fund that you have opened. Your mother is a nominee everywhere. As soon as you open the account, whether even if it's a Demat account or anything, it's a single name and your mother is a nominee. As soon as you get married, or maybe 1 year or within a year, you have to change the designations, especially for important assets like PF, right? You have to make those changes, because in case you drop dead, it should belong to your wife. Similarly, if you've taken a loan with your wife to buy a house, the nominee in that policy has to be a wife, because your wife has to repay the loan. Though I know cases where I have actually suggested the mother be the nominee, where the mother contributed to the house and the mother also gave guarantees, right? So mother gave guarantees. Mother's name was not, she was not the owner. Mother had money she had got from her provident fund. She had just retired, so she put that money for a house that her son was buying. In that case, I suggested that he should take a insurance policy with his mother as a nominee. So he took 2 policies, one with his mother as a nominee for the loan amount, and one with his wife as a nominee for the loan amount, right? So this was a loan given by the mother, that was loan given by HDFC. So he had to take 2 policies. I suggested that he take 2 policies, one with the mother, one with the wife as a nominee. So make sure that you make all the changes in the nominations, whether it is a housing society, whether it is a mutual fund, whether it is provident fund, especially if your mother is no longer alive, which means there is no nominee, right? You nominated your mother has passed away. Now it is important for you to make your wife the nominee, in case you have not already done it. You should have, of course, done it as soon as you got married, but in case you have not done it and it's a good family, so you didn't bother, but your mother is dead, so then you have to change the nominee. So make sure that your nominations are current. If you had not named your children because they were minor and now they've grown up, then make them the nominee. So make sure that your nominations are current, and if you make a will, make sure that the will and the nominations that you have done are in sync with each other. Don't nominate your son in the mutual fund form and your daughter in the will. I mean, don't create conflicts like that, which is unintentional and absolutely not worth it. Another thing which I see as a big mistake is not making, assuming that joint ownership will anyway pass on to the other person. Not true in real estate. Just because you have a house which you own jointly with your husband, it does not mean in the case of your husband's death, it will automatically come to you. It may not come to you. In case of your death, it will not go to your husband unless you write this down in a will. Then the distribution of assets could be as per the Hindu Succession Act and not as per your will. So whatever is your intention, please put it down in a will. So make sure that joint properties are mentioned separately, and you tell them that in case of A dies, it belongs to B. In case of B dies, it belongs to A. In case A and B both die, then it should belong to their children or whatever it is. But make sure that joint properties are also considered. Don't ignore them saying, oh, it's a joint property, so it will go automatically. It does not go automatically. Don't overlook the tax implications. Right now there is no estate duty, but you can expect it to come. But there could be capital gains tax in case the people who inherit your property and then sell it, when they are concerned. There is no other income tax law applicable. Right now there is no income, that's only inheritance. There is no inheritance tax as of now. Another mistake which I see people making, which a lawyer should never allow this to happen. A lawyer will not allow this to happen, but I see people making this mistake, is not nominating who will manage the money when the children are minor. Now these are things which only a lawyer will tell you, which people don't understand, so they just go down to Google and just print it and keep it there. These people forget that they have to also attach a doctor's certificate in case it is challenged. Now what happens is 99.9% of cases with which we deal is rarely challenged. So even all your mistakes are okay, because just the housing society needs a will, so that is given so that the house is transferred to the nominee. That's all. But you have to be far more careful with the documentation. If there is family property, if there is business property, if there is big joint property, if something has to come from the joint family HUF, or something which is under scrutiny, some litigation, then all those things have to be mentioned. Be careful, especially for people with complicated assets, right? So don't assume that oral wills are sufficient. Oral wills are sufficient in India only in certain particular Muslim communities, may not be sufficient for you, right? Another thing is, after a particular age, if you're sure, let's say you're 75 years of age and you're sure that you're not going to buy any more real estate or sell. You may be, if you're forced to, that's a different thing, but you won't. Normally you won't. Then go and get your will registered also. There are 3 stages. One is making the will. It can be handwritten, but you're much better off keeping a nice typed one, so that there is no spelling mistake or things like that which is not got noticed, right? So you don't want any mistake like that. So have it typed. Have it notarized. That is step 2. First, make it, sign it. There has to be witnesses, 2 witnesses, and a doctor's certificate. Attach it, and then get it notarized. Notarizing helps, because then if you have to go and create a probate or even to register, they know that this is not a document created today. It is a document created long back. The notary's records can be searched, because there will be an entry saying so and so stamp duty paid 150 rupees, 300 rupees, whatever it is, right? So all those things will be mentioned. So the court will look at a will with a proper notary as a better bet than a non-notarized will. But you can always go and get it registered if you think this is the last will that you are making. Many people also fail to mention liquid assets which are being fought in the family courts and wars and things like that. So be careful about mentioning all those assets, and say these are some assets where there is a dispute. I do not know what is going to happen in the dispute. In case the dispute dissolves, in the case the dispute solves, this asset will go to so and so, right? So plan for the liquid assets, illiquid assets, etc. Family disputes, all that has to be taken account. In case you have a lot of property and and you have a son, maybe 2 sons, it's better of creating a trust so that a big amount of the property is not lost to a bad marriage, right? So you don't want your daughter-in-law to sue and take away everything from your son. So then it might require creating a trust, right? So don't forget your digital assets. For me, digital assets is my blog, it's my YouTube channel, etc. I can nominate here also. So I need to take care of all those digital assets, pets, gold jewelry lying at home, on the body, right? All those things have to be, you draft a clear will, review it periodically whenever there could be a change in the nomination, etc. And consider consulting a lawyer familiar with all this before you jump and create it, right? So thank you.